this is Dan Smith of DPS Legal Counsel, and welcome to today's video episode of Legal Scrubs, where I discuss issues of importance to physicians in private practice and sometimes to small business entrepreneurs. Because let's face it, doctors are entrepreneurs as well. So today I want to talk about one thing that any small business can do right now without leaving the house in preparation for that day when business gets back to normal after the coronavirus lockdown or shutdown. One thing that every small business can think about at least doing, or one idea that they might want to look into while they're at home and unable to leave the house. One thing you can actually do from home and in preparation for the time when the lockdown is over. So what is that one thing? Well, that one thing is looking into filing an intent to use trademark application with the U.S. Patent and Trademark Office. What is an intent to use trademark application as opposed to a normal trademark application? Well, a normal trademark application is an application where you file for a registered trademark with the USPTO, and essentially you need to certify that you are using that trademark in commerce already, because you have to put a date on your application when that sets forth when you first used that particular trademark in commerce. An intent to use trademark application, on the other hand, is filing a trademark application to get rights to a particular trademark before you use it, while you still are just in the position of having an intent to use it. And so that's why it's called an intent to use trademark application. So you don't have to have used the trademark. You can dream up a trademark that you think you might like to use in your business at some point and file an intent to use trademark application, get rights to that particular trademark, and then once you get your trademark intent to use application approved, you will have 6 months in which to actually use the trademark in commerce, file an affidavit for showing that use, and have your trademark application actually proceed to being a registered trademark. So I said that's a lot of information. Let me back up and try to break that down a little bit. If you have a trademark that you think you might like to use for your business and you want to get rights in it today, in advance of actually using that trademark in commerce and in business, you can file what is called an intent to use trademark application with the U.S. Patent and Trademark Office. You file your application, you give a specimen of your proposed trademark, which is one that you're not using now, but you intend to use or you might use in the future for your business. You will get back from the USPTO, if that trademark is available to you, what's called a notice of allowance, or an NOA, which means that you have the right to use that trademark, and once you use it and can prove you're using it in commerce, your trademark application will proceed to final registration, and you will then end up with a registered trademark. So step one, you file your intent to use trademark application. Step two, you get a notice of allowance from the U.S. Patent and Trademark Office saying, yes, this trademark is available to you, and once you use it, essentially saying once you use it and can prove it, your case will proceed to federal to registration for that trademark. Number three, you use your trademark in commerce. Number four, you file an affidavit with the USPTO indicating that you have used it and the date of first use in commerce. Number five, you'll get back in due time a notice that your trademark is proceeding through the registration process, which means it's going to be published in the official gazette that the USPTO publishes. Then after the opposition period runs, and if there's no opposition to that trademark proceeding to final registration, you'll get your final registration. Now, if you do file an intent to use trademark application and you get a notice of allowance for that intended to use trademark, you'll have 6 months in which to use your trademark in commerce and to file your affidavit showing that you have used it. If you don't use it, or it doesn't appear that you're going to be able to do that within a 6-month period, you can file for an extension of that 6-month period and get an additional 6 months. You can do that several times up to, I believe the period is up to a 3-year period that you have to actually use that trademark if you need extensions. But originally, when you get the notice of allowance, you have an original 6 months in which to use your trademark and then to file your affidavit showing that use. So right now, even though we're under a lockdown because of the coronavirus, if you've been thinking about using a particular new trademark in your business, this would be a perfect time while you're at home to look into filing an intent to use trademark application. If you need an attorney to help you with that process, that's something that I can do and can help you with that intent to use trademark application. Okay. I hope that helps, whether you are a physician who wants to look into having a trademark for your practice, or you're a small business that wants to look into having a trademark for your business, or maybe an additional trademark for your business. This would be a great time while businesses maybe slow down or not going on its normal way, to look into down the road a bit, looking down the road a little bit, and looking at what you might want to do within the next 6 months on putting a new trademark into place for your practice or your business. All right, I hope that helps, and we'll talk to you again on Legal Scrubs. Thanks.